The most powerful weapon in the arsenal of criminal defense is the standard of proof beyond and to the exclusion of every single reasonable doubt. I am absolutely amazed and shocked at how many attorneys will simply leave that alone in the arsenal and reduce their case to a civil standard of proof and thereby lose many cases that could otherwise be won. What is required in a criminal trial practice before a jury is that the jury must understand, and they must also believe, as the jury instructions indicate, that proving the case is simply not enough in order to return a verdict of guilty, that the case has to be proven beyond and to the exclusion of every single reasonable doubt. Well, it's a mouthful to say, and you can bet that people will simply tune that out unless you break it down, unless you have that jury to understand exactly the awesome responsibility that's imposed in fulfilling that area of the law. What I refer to it as is super proof. For example, you need a commitment from the jury early on that they understand that simply proving this case is not enough. They must go beyond that. The proof has to be so pristine, so pure, that they don't have so much as one single reasonable doubt about it. And yes, ladies and gentlemen of the jury, you could actually leave this or any case with a personal opinion that a given defendant on a given day did something, but yet you found the defendant not guilty. Why? Because you will not make that decision back there in the jury room based upon the type of reasoning that you use on the street when making a decision with your simple gut. You will subject it to super proof. Proof beyond and to the exclusion of every single reasonable doubt. And so you ask the jury simply this: listen, you understand that if I give you, or rather if the state gave you 1,000 reasons to convict, you would simply say, if you had so much as one single reasonable doubt, that the defendant was not guilty. Now, what does that mean? And I'll ask the jurors, what does that mean? What does not guilty mean to you? Well, a lot of jurors will say, well, it means they didn't do it. Then you'll go to another juror. What does it mean to you? Well, it means they didn't prove it. And there you go, you've got the stage set right there to bring home to the jury, to hammer home to them what that duty is. It does not mean that somebody did not do something. It simply means this. It means that the level of proof before this court, based on the evidence, which is all you can consider, was not met, and therefore the defendant was declared not guilty because of that failure of proof. An attorney does his client and the justice system a gross disservice when they get into this argument of, did do it, my client didn't do it. Those are issues that can be skirted, but yet still effectively presented to the jury while preserving the standard of what I call super proof. When you reduce a case to did do it or didn't do it, what happens simply is this. The jury does not understand that it's a different process. Number one, has the case been proven is the first thing they look at. If it has been proven, they must go beyond the fact that it's proven and not have so much as one single reasonable doubt about that proof. You hammer this concept hard in the closing argument. This argument is particularly good where you've got a client that looks for the world like it's guilty, and you've got a factual case that looks very bad against you. I've seen this concept work. I've seen it work many times. I've seen it work where a felon that was supposedly in possession of a firearm right in the room is found not guilty. I've seen it work in a murder case where there's 5 eyewitnesses that went to high school with the person that they said was the shooter. This is the most critical error that lawyers make when they're arguing criminal defense cases. They simply give up the main thing that is the hallmark of the entire system, and what they do is they simply sacrifice a client's constitutional right to a fair trial based on constitutional principles right there on the altar of justice. There's no excuse for it. It's disgusting.